Namaste viewers, a warm welcome to this new episode of the Indian Lawyer Legal Tips. Today's topic is going to be of great interest to many. It's the law of marriages in India. I am Sushila Varma, bringing to you small tips on how marriages are performed in India. In India, we have three types of laws which govern the marriages in India. As we all know, marriage is a very sacred institution, not only in India, but worldwide, and it is deeply rooted in the culture and tradition of people. Now let us start with the first type of marriages that happens under the Hindu law. The Hindu Marriage Act 1950 is the act that has been enacted to bridge the gap between age-old customs and modern legal principles. It governs the Hindus, the Buddhists, the Jains and the Sikhs. In India, we have three types of laws that govern marriages in India. The first is the Hindu Marriage Act 1955. The second is the Muslim personal laws, and the last is the Special Marriages Act, which deals with marriages between different communities, castes or even different nationalities. So let us begin first with the Hindu Marriage Act. The Hindu Marriage Act governs not only the Hindus but includes the Buddhists, the Jains and the Sikhs, and it provides a robust structure for solemnizing and legalizing the marriages that take place under the Hindu laws. Now the next thing that would interest us is what are the conditions of a Hindu marriage, that is, what are the conditions that have to be met when one is solemnizing a Hindu marriage. The first is monogamy, that is, neither party should have a living spouse at the time of marriage, because if he or she has another spouse at the time he or she is getting married, it would deem to be bigamy, which is an offense under the law. Secondly, mental capacity. Both parties must be of sound mind and capable of giving valid consent at the time of marriage. They should not be suffering from any mental disorders that makes them unfit for marriage or procreation. Third is the age requirement. The minimum age for marriage would be 21 for the bridegroom and 18 for the bride. Now the next point is, how does a Hindu get married? The Hindu Marriage Act emphasizes that certain ceremonies are very critical in solemnizing a marriage. Amongst them, the Saptapadi ritual is of the utmost importance. The Saptapadi ritual means the bride and the groom will take 7 steps around the sacred fire, and once this is done, it is deemed under Hindu law that they are married. Another thought that might cross a person's mind is that can anybody who falls within the definition of Hindu get married? I would answer this by saying no. There are certain prohibited degrees of relationships under the Hindu laws where they are not allowed to get married, because such relationships would be considered incestuous unions. These would be lenient ascendants, that is father, grandfather, lenient descendants, that is son, grandson, siblings, that is half siblings and step siblings, uncle and niece or aunt and nephew. Such relationships are prohibited to ensure moral and social order. However, there are exceptions made for these prohibited relationships in case the customs or of certain communities permit it. That is the reason why we have certain marriages in India which are between uncle and niece, or between the son and daughter of two sisters, although the Indian laws and more specifically the Hindu laws prohibit it, yet they are such marriages that are happening. What would be the consequences of a prohibited marriage? A prohibited marriage would be declared void if anybody was to raise the issue. Apart from that, there could also be simple imprisonment for 1 month and fine imposed on the parties that have committed a prohibited marriage. Now let us understand the purpose of registration of marriage. Registration of marriage is important because it is a legal proof of marriage. It also helps in preventing child marriages, bigamy, and certain disputes. However, registration of marriage is not mandatory under the Hindu Marriage Act. Now, let us understand how one can register marriage. Registration of marriage is very simple. One has to approach the local registrar's office, present the documents such as age proof, identity proof, wedding photographs, etc., and then the registrar will register the marriage. Now let us understand when a marriage can be voidable. A marriage can be voidable if one of the parties is impotent, or if one of the parties is of unsound mind, or if the marriage has been performed by fraud or coercion and through deceit or force, or if the bride is already pregnant with a child at the time of marriage. In all these cases, a marriage is voidable, and the party who wants to declare the marriage void must approach the necessary court. Law on marriages for Hindus is the Hindu Marriage Act 1955. It provides a comprehensive legal framework to regulate Hindu marriages in India, uphold the sanctity of marriages while ensuring legal and social compliances. In the event that you have any questions on this particular law, you may write to us on the link given below. Now the next topic that we will touch is the Muslim laws. Who does this law apply to? In short, Muslim personal laws apply to only those people who are Muslims by religion or who are governed by Islamic principles in personal matters like marriage, divorce, inheritance, maintenance, etc. Now, a Muslim is deemed to be a person by birth, by conversion, or by community. It is important to note here that non-Muslims married under special laws are not governed by the Muslim personal law, even if they are married to a Muslim. Now, let us understand what are the steps that have to be followed in a Muslim marriage. A Muslim marriage, which is also known as nikah, is in the nature of a civil contract rather than a religious ceremony. It has three aspects. First is the proposal and acceptance, which is also known as ijab or kubul. That is, one party makes a proposal and the other accepts it. The second aspect is that there has to be some witnesses who will witness the marriage. And the third and probably the most important is the meher or the dower, in which the groom has to fix a certain amount which he has to give to the bride. This is also known as meher. Apart from this, both parties would also have to consent freely, and though registration of a marriage is not compulsory under Muslim laws, it is always advisable to get one's marriage registered as it helps in many aspects. Generally, a Muslim marriage is solemnized by the Qazi who oversees the marriage ceremony, which is known as Khutbah-e-Nikah. Now, who is eligible to get married under the Muslim laws? First, that they have to be of Muslim religion. Second, they have to attain the age of puberty. The legal age for marriage in most jurisdictions is 21 for men and 18 for women. Thirdly, the person must have the mental capacity to consider the offer and accept the same. What are the prohibited relations for marriage under the Muslim law? The answer is consanguinity, that is blood relations. Marriage is prohibited between close relations such as mother, grandmother, great-grandmother, daughter, granddaughter, great-granddaughter, sister, half-sister, step-sister, aunt, maternal or paternal, and niece. Another important aspect of Muslim laws that has to be pointed out is the iddat period. In the event that a Muslim marriage is being performed in which one of the parties is a divorcee and she's a woman, then an iddat period has to be maintained, that is the waiting period after divorce or the death of her husband before she can get married. Now let us come to what are the rights of a woman under the Muslim marriage laws. The woman will have a right to meher as her property, right to inheritance, right to maintenance, right to security and companionship, and right to seek divorce on specified grounds. Similarly, the obligations of the husband would also be payment of meher, providing maintenance to his wife, and treating the wife with dignity and fairness. Now, let us touch upon the last law which is important in India for marriages. This is what is known as the Special Marriage Act 1954. The Special Marriage Act 1954 applies to individuals who wish to solemnize their marriage irrespective of their religion, caste or nationality. What are the categories of people who can come under the purview of this act? These are mentioned in the slides below. Individuals from any religion or no religion, interfaith and intercaste couples, Indian nationals and foreign nationals. The Special Marriages Act extends to Indian citizens as well as foreign nationals who are residing in India or who have come to India for the purpose of getting married. Now, what is the legal age for marriages under the Special Marriage Act? It's the same as it would be for the other laws, that is 21 for the groom and 18 for the bride. The next question would be, are there any prohibited marriages under the Special Marriage Act? The first would be consanguinity, that is marriage between close blood relatives. Affinity, that is marriage between a person and the spouse of their living parent, that is step-parent, is prohibited. Mental incapacity, where the person is of unsound mind or mentally disabled. Or bigamy, that is if one of the parties already has a spouse who is living. Additionally, marriages between first cousins, both paternal and maternal, are also prohibited under the Special Marriages Act. Now, can a marriage that has been performed under the Special Marriage Act be declared void? The answer is yes. A voidable marriage performed under the Special Marriages Act can be declared void if the person who is asking for annulment can show to the court that the other party was willfully refusing to consummate the marriage, or was pregnant at the time of marriage, or was coerced or forced into the marriage, and the free consent for the marriage was never given. Last question under this particular section is, can a person get married while he or she is undergoing divorce proceedings? The answer is an emphatic no. The Indian laws do not permit people to get married while a divorce proceeding is still ongoing. It is mandatory that one must have a divorce decree before going for a second marriage. With that, we come to the end of this episode. We have just touched upon the basics of each law. And if you have any particular question, you will have to raise it with lawyers. This episode is only educational in nature and cannot be deemed to be legal advice. If you have found this episode useful, please like, share and subscribe, and please press on the bell icon so that you can get notified for the next episode. Thank you and have a good day.